Greetings, my fellow Jimbo Southern Thinkers. Reviews podcast. My name is Craig, transmitting from this business, once again in South Florida. And today's date is Wednesday, May 22nd, 2019. So let us begin. Sorry about that, folks. A little bit of a delay. They want to do a little run around on me. That's okay. I can use the web console. My app's been compromised, so I might have to just reset it. I'll do that in due time. Yes, so I'm at Downtown Saloon, located at 10 South New River Drive, East, in the heart of downtown Florida, along the New River, not far from the courthouse. Right across the river from Huizenga Park, which is known as Bouvier. Government likes to privatize things, I would say. Pretty absurd. Well, to be very frank, I'm going to be mainly focusing on the controversial law. Did a little homework on it the past couple days. And it's mainly about Alabama's Human Life Protection Act. And of course, a lot of pro-choices out there went up in arms around the country and mocking the state of Alabama, etc. It's not to say a pros or cons or anything like that, or have my own personal views in good faith. However, it's not going to be mainly addressing my personal intake. However, there's a lot of little history about this amendment and how the people voted and who funded it. Very intriguing, I would say. And it's mainly from Ballotpedia.org. And the first one we talking about right here is it is called Alabama. It was known as Alabama Amendment 2 State Abortion Policy Amendment in 2018. And it's interesting here because it says here about the Alabama State Abortion Policy Amendment. Amendment 2 was on the ballot in Alabama as legislatively referred constitutional amendment on November 6, 2018 was approved. Yes, a vote supported this amendment to make it a state policy to recognize and support the sanctity of unborn life and the rights of unborn children, including the right to life, and to state that no provisions of the Constitution provide a right in abortion or require funding of abortions. Of course, it says no. A no vote opposed this amendment to make it state policy to recognize and support the sanctity of unborn life and the right of unborn children, including the right of life. That the state has no provision of the Constitution to provide a right in abortion or require funding of abortion. So it was voted on by the people, and I'll just look at we'll look at the results a little bit. And of course, in 2019, Bill 134 signs a law. On May 15, 2019, Alabama Governor Kay Ivey, Republican, signed a bill into law prohibiting all abortions in the state except those necessary to prevent a serious health risk to the woman. House Bill 134, called the Human Life Protection Act, reclassifies performing abortion as a felony punishable with up to 99 years in prison. So a lot of it's a big question, really like a red flag to those folks that are pro-choice. But I'll continue on here. Today, I signed into a law the Alabama Human Life Protection Act, a bill that was approved by overwhelming majorities in both chambers of the legislators. Ivey sent a statement to the bill's many supporters. This legislation stands a powerful statement for Alabamians. Deeply held belief that every life is precious and that every life is a sacred gift from God. We vow to fight this dangerous abortion ban every step of the way, and we meant what we said. Stacey Fox, President and Chief Executive Order of the Planned Parenthood Southeast, told CBS, "We haven't lost a case in Alabama yet, and we don't plan to start now." It's interesting because someone made a statement they're all men, white men that voted for this and so forth and signed the law. Well, just to let you know, folks know, Kay Abby's a woman who signed it. So all you chauvinists out there, male guilt, white guilt, don't matter. Inapplicable, to be exact. And interesting about this is the one happened here in a wrongful death suit on February 6, 2009. Ryan Magers, an Alabama resident, filed a wrongful death lawsuit against Alabama's Women's Center for Reproductive Alternatives, its employees, and a pharmaceutical company over an abortion received by Magers' girlfriend in February 2017. The lawsuit states the plaintiff as Ryan Magers individually and on the behalf of his deceased child, Baby Roe. The lawsuit argues that the Alabama law, an unborn child is a legal person, which makes the argument based in part of the provision of the state constitution added by Amendment 2. On March 5, 2019, Madison County probate judge Barger decides that Baby Roe was a person with a legal rights and the lawsuit to go to forward Magers representing Baby Roe's estate. Then there's plenty of links, you can look that up. And it's interesting about the amendment bill, Alabama Amendment 2, from 100 precincts reporting 100%. 916,061 voted yes, which is 59.1%. Endorsed it, and 636,438 voted no, and it was under 41% or 40.99%. And we just look at the overview here. What did the amendment do? Amendment 2 amended the state constitution in order to do the following. A, declare that the state policy is to recognize and support the sanctity of unborn life and the rights of unborn children, including the right to life. B, ensure that protection of the rights of the unborn child in all manners and measures lawful, appropriate. And C, state that nothing in this Constitution secures and protects a right to an abortion or requires the funding of an abortion. We can use Roe v. Wade. Ruling prohibits states from banning abortion prior to fetal viability, which was defined as potentially eligible to live outside the mother's womb. Representative Matt Freedy, Representative Republican District 72, who sponsored this amendment in the legislature, said its purpose was to ensure that nothing in the state constitution could be used to argue for a right to an abortion in the event that Roe v. Wade was overturned. I will add, of course, the Roe v. Wade case in my footnotes here as well, and you could read it for yourself, but I will talk about it in a little bit. Status of abortions in Alabama. Although Roe v. Wade prohibited banning abortions prior to fetal viability, the Supreme Court held that states can regulate and/or abortions once fetus reaches the point of viability. In Planned Parenthood versus Casey of 1992, the Supreme Court reaffirmed the essential holding of Roe v. Wade, but rejected the trimester framework established in the case. The High Court affirmed that states could not ban abortions before fetal viability. According to the court, neonatal care developed since Roe v. Wade meant fetal viability occurred somewhat earlier than the start of the third trimester of pregnancy. As of 2018, Alabama is one of the 43 states that ban abortion beginning at a certain age state of pregnancy. Alabama's banned abortion starting 20 weeks after fertilization. Amendment 2, support and opposition. This is interesting here. Ballotpedia identified one committee registered to support Amendment 2, Alliance for Pro-Life Alabama. The committee has raised $7,993 and has spent it all. The top donor was Briar Presbyterian Church, who gave $2,500. All right, and we'll just go here. Ballotpedia identified two committees registered to oppose Amendment 2. Alabama for Healthy Families and Alabama students voting no on Amendment 2. Together, the committee has raised $1.56 million and had spent $1.51 million. The top donor of the to the support committees was planned. For Planned Parenthood, which gave 1.39 million in cash and in kind contributions. Well. So Planned Parenthood actually, let me see. This includes, excuse me here. This includes Planned Parenthood Action Fund, Planned Parenthood Southeast, Planned Parenthood Advocates of Marmonte, Planned Parenthood of Orange and San Bernardino counties. So you got Planned Parenthood from counties of California coming in and telling Alabama how to vote. Planned Parenthood Federation of America, Planned Parenthood of New York Action Fund, Planned Parenthood Greater Memphis Region. They have a lot of out-of-state, of course, national organization funding it down. Nothing new. You always have outsiders trying to tell other states how to live and think. Very interesting indeed. And they still lost. I think that's why Planned Parenthood was ticked off about this, because they lost a good amount of money. Their investment went down the drain. Of course, here, 2018 ballot measures surrounding abortion. I'm not, okay, I don't have to really go there. That's unnecessary. And, of course, we get the ballot title. I'm just going to look at this. I'm not going to go too technical, but I will just go further down up to constitutional changes. And you can read the rest of it here. Like I said, ballot title. The ballot title was as follows: proposing an amendment to the Constitution of Alabama of 1901 as amended to declare and otherwise affirm that this is a public policy to the state to recognize and support sanctity of unborn life and the rights of unborn children. Most importantly, the right to life in all manners and measures appropriate and lawful, and to provide that the Constitution of the state does not protect the right of abortion or require the funding of abortion. Those are what the ballot summary has to say. The plain language summary provided by the state's Fair Ballot Commission was as follows: under current law, the state constitution does not include any language that directly relates to the importance of unborn life or the rights of unborn children, nor does it include any language that directly relates to abortion or the funding of abortions using state funds. Amendment 2 provides that it would be a public policy of the state to recognize and support the importance of an unborn life and the rights of unborn children, including the right of life and to protect the rights of unborn children. Additionally, the amendment will make clear that the state constitution does not include a right to an abortion or require the funding of an abortion using public funds. The proposed amendment does not identify any specific actions or activities as unlawful. It expresses a public policy that supports broad protections for the rights of unborn children as long as these protections are lawful. So in this case here, we've got the constitution changes. This here, Amendment 2 as a new amendment to the Constitution. The following text was added. The state acknowledges, declares, affirms that it's public policy to the state to recognize and support sanctity of unborn life, the rights of unborn children, including the right to life. B. The state further acknowledges, declares, and affirms it is a public policy of the state to ensure the protection of the rights of the unborn child in all manners and measures lawful and appropriate. C. None of this Constitution secures or protects the right to an abortion or requires the funding of an abortion. In their Alabama Constitution. What does we have to say here? Doesn't really go that far. So we'll just head back here. That's interesting. So they don't want to do public funding. So that's very interesting. Not too surprised here. So it's like share the wealth, right? Okay. Of course, you got the supporters and against and all that. Organizations that vote no on Amendment 2. It can go on and on. Of course, campaign finance. That shows you more detail. Wow. And of course, it's interesting here. Others like add this to it. Jubilee Ministries, the cash of $1,510 in the Alabama Pro-Life Coalition, Inc., $1,500 all in cash. And of course, the opposition. Of course, Alabama for Healthy Families, and it's like cash contributions, $1,366,475, and of course, Alabama students for, of course, in-kind services. It gives you a whole rundown on here. Interesting here, and of course, Planned Parenthood organizations. They put in most of it with their contributions. Of course, ACLU of Alabama, the in-kind donation of in-kind $1,058.80, and the ACLU $303 in-kind contribution. So you got the Feminist Majority Foundation. They did theirs, total of $36,701.70. So of course, you have the video editorials and all that stuff. Opposition, Roe versus Wade. And I'll tell you all about it here. So this is gonna be interesting. For the most complex battle, you could say, in good faith. And of course, it'll be a 10th Amendment dispute as well, a debate. It'll be like right of privacy at a federal level versus states' rights. Well, I'll just keep on going here. I'm gonna look. It's from LegalScan.com. And it tells you all about it here. All about this stuff here. And it says like here on this bill that signed into law, an act related to abortion, to make abortion and attempted abortion felony offenses, except in cases where abortion is necessary in order to prevent a serious health risk to the unborn child's mother, to provide that the woman who receives an abortion will not be held criminally culpable or civilly liable for receiving the abortion. So, okay, we have some exceptions here. And the connection therewith would have its purpose or effect the requirement of a new or increased expenditure of local funds within the meaning of Amendment 621 of the Constitution of Alabama of 1901, appeared in Section 111.05 of the official compilation of the Constitution of Alabama as of 1901, as amended, be enacted by the legislature of Alabama. 1. This act shall be known as the Alabama Human Life Protection Act. 2. Legislative findings. The state's statute criminalizing abortion, Section 13A-13-7, Code of Alabama 1975, has never been repealed. It has remained unenforceable as a result of the Supreme Court decision in Roe v. Wade, 410 U.S. 113, as of 1973, and its progeny was struck down as unconstitutional. A Texas statute criminalizing abortion, which effectively repealed by implication and made unenforceable in all other states statute criminalizing abortion. Interesting here. So we'll go B. On this act, on November 6, 2018, electors in the state approved the majority of a vote a constitutional amendment to the Constitution of Alabama of 1901, declaring that affirming the public policy of the state to recognize and support the sanctity of unborn life and the rights of unborn children. The amendment made it clear that the Constitution of Alabama does not include the right to abortion or require the funding of abortions using public funds. In present state law, Section 13A-6-1, Code of Alabama 1975, defines a person for homicide purposes to include an unborn child in utero at any stage of development regardless of viability. D. The United States Declaration of Independence, the principle of natural law, which means all men are created equal, was articulated. Self-evident truth found in natural law, and that all human beings are equal from creation, was at least one of the bases for the anti-slavery movement, the women's suffrage movement, Nuremberg war crime trials, and the American Civil Rights movement. If those movements had not been able to appeal to the truth of universal human equality, they could not have been successful. Abortion advocates speak women's rights, but they ignore the unborn child, while medical science has increasingly recognized the humanity of the unborn child. F. Recent medical advances prove a baby's heart starts to beat in around 6 weeks. About 8 weeks, the heartbeat can be heard through the ultrasound examination. A fetal Doppler can detect a fetal heartbeat as early as 10 weeks. Ultrasound imaging shows a developing child in utero. As early as 6 weeks after fertilization, fetal photography shows the clear development of a human being. The Alabama Department of Public Health publication, Did You Know, demonstrates through actual pictures at 2 weeks intervals throughout the entire pregnancy the clear images of developing human being. It is an estimate that 6 million Jewish people were murdered in German concentration camps during World War II. 3 million were executed by Joseph Stalin's regime in Soviet gulags. 2.5 million people were murdered during the Chinese Great Leap Forward in 1958. 1.5 million to 3 million people were killed by the Khmer Rouge in Cambodia during the 1970s, and approximately 1 million people were murdered during the Rwandan genocide in 1994. That's considered a 100-day genocide. All of these are widely acknowledged to have been crimes against humanity. By comparison, more than 50 million babies have been aborted in the United States since that Roe decision in 1973. More 3 times the numbers who were killed in German death camps. Chinese purges, Stalin gulags, Cambodian killing fields, and Rwandan genocide combined. That's why it probably took off a lot of people. One of the reasons I see here. J. The case of Roe vs. Wade and its progeny have endangered much civil litigation and legislative attempts to rein in so-called abortion rights. Roe vs. Wade attempted to define when abortion of an unborn child would be legal. Judges and legal scholars have disagreed and dissented with this finding. Section 3, as used in this act, the following terms shall have the following meanings. 1. Abortion, the use or prescription of any instrument, medicine, drug, or any other substance or device with the intent to terminate the pregnancy of a woman known to be pregnant with known knowledge. A little windy here. Yeah, so I have a ceiling fan that's above me. You may hear the wind in the back. Sorry about that, folks. And terminate the pregnancy of a woman known to be pregnant with knowledge, with determination by those means, will, with reasonable likelihood, cause the death of unborn child. The term does not include these activities if done with the intent to save the life or preserve the health of an unborn child, remove a dead unborn child, to deliver an unborn child prematurely, to avoid a serious health risk to the unborn child's mother, or to preserve the health of her unborn child. The term does not include a procedure or act to terminate the pregnancy of a woman with an ectopic pregnancy, nor does it include a procedure or act to terminate the pregnancy of a woman when an unborn child has a lethal anomaly. 2. Ectopic pregnancy, any pregnancy resulting from either a fertilized egg that has been planted or attached outside the uterus, or a fertilized egg is planted inside the cornu of the uterus. Lethal anomaly, a condition for which an unborn child will die after birth or shortly after be stillborn. Medical emergency, a condition which, in reasonable medical judgment, so complicates the medical condition of the pregnant woman that her pregnancy must be terminated to avoid a serious health risk as defined in this act. 5. A physician, a person licensed to practice medicine and surgery, or osteopathic medicine and surgery in Alabama. A serious health risk to the unborn child's mother. In a reasonable medical judgment, the child's mother has a condition that so complicates her medical condition that it is necessity the termination of her pregnancy to avert her death or to avert serious risk of substantial physical impairment of a major bodily function. This term does not include a condition based on the claim that the woman is suffering from an emotional condition or a mental illness which will cause her to engage in conduct that intends to result in her death or the death of her unborn child. However, the condition may exist if a second physician who is licensed in Alabama as a psychiatrist with a minimum of 3 years of clinical experience examines the woman and documents that a woman has diagnosed serious mental illness, and because of it, there is reasonable medical judgment that she will engage in conduct that could result in her death or the death of her unborn child. If the mental health diagnosis and likelihood of conduct is confirmed as provided in this act, and it is determined that the termination of the pregnancy is medically necessary to avoid the conduct, the termination may be performed and shall only be performed by a physician licensed in Alabama, in a hospital as defined in the Alabama Administrative Code, to which he or she has admitting privileges. There are exceptions to the rule. 7. Unborn child or person, human being specifically, including an unborn child in utero at any stage of development, regardless of viability. 8. Woman, a female human being, whether or not she has reached the age of majority. 4. It shall be allowed for any person to intentionally perform or attempt to perform an abortion, except as provided for by subsection B. As it says here, an abortion shall be permitted if an attending physician licensed in Alabama determines that abortion is necessary in order to prevent a serious health risk to unborn child's mother, except in the case of a medical emergency as defined herein. The physician's determination shall be confirmed in writing by a second physician licensed in Alabama. The confirmation shall occur within 180 days after the abortion is completed. Shall have prima facie evidence for a permitted abortion. So prima facie, just to let you know, folks know, prima facie in Latin means on his face. Documented on his face. Okay? Section 5. No woman upon whom an abortion is performed or attempted to be performed shall be criminally or civilly liable. Furthermore, no physician confirming the serious health risk to the child's mother shall be criminally or civilly liable for those actions. Section 6A. An abortion performed in violation of this act is a Class A felony. Interesting there. That's a capital offense. Grand jury, can we say? B. An attempted abortion performed in violation of this act is a Class C felony. 7. This act shall not apply to a physician licensed in Alabama performing a termination of a pregnancy or assisting in performing a termination of a pregnancy due to a medical emergency as defined by this act. Section 8. The Constitution of existing statutes and regulations that regulate or recognize abortion in Alabama that are in conflict with antagonistic to this act shall be repealed as null and void. Recognize the prohibition of abortion as provided in this act. This act is challenged and enjoined pending a final judicial decision. Existing statutes and regulations that regulate or recognize abortion shall remain in effect during that time. Section 9. Although this bill would have as its purpose or effect the requirement of a new or increased expenditure of local funds, the bill is included from further requirements and application under Amendment 621, now appearing as Section 111.05 of the official recompilation of the Constitution of Alabama 1901, as amendment, because the bill defines a new crime or amends the definition of an existing crime. It says Section 10, this act shall become effective 6 months following its passage, approved by the governor, or is otherwise becoming law. So, 6 months from now, I would say September 14th. 6 months? No, November. Around November. So, of course, you got the folks in the Speaker House of the House. They represent it. Presiding officer and all that good stuff. Well, I would say. Very intriguing indeed. So, there will be a lot of controversies with this thing. And it's understandable. I'm not going to debate on that by any means. But one of the areas you got to look at, folks, it can still be challenged. Remember here's the one thing you could do. The folks can still do a grand jury. If a grand juror doesn't believe this person did murder, they can say no to indict, not to indict. And even in jury trial, one person can hang a jury, even in Alabama. So you got those areas if you want to counter this particular law, this law itself on abortion. That's why we have a 3-vote system in this country, and a lot of states within the union do honor that. So it was passed by the House the 30th of April, and Senate passed it on the 14th of May. So it's going to be even on the state constitution challenge. They can look at that as well, because sometimes they do intertwine with each other. And right here, according to Article 1, Section 1, equality of rights of men, that all men are equal, free, and independent. They are endowed by their Creator with certain inalienable rights. That among these are life, liberty, and pursuit of happiness. So that area, it can work both ways. One of them is the right of privacy. That's considered an inalienable right, correct? That could be challenged. So there's going to be some challenges on this. People are a source of power. All political power is heritage of the people, and free governments, and all free governments are founded under author and instituted for their benefit, and that therefore they have at all times an inalienable and indivisible rights to change their form of government in such matters as they deem expedient. So folks can look at that too. Of course, we can hit number 8. All right, we hit number 8. Yeah, let me see what number 8 has to say. It's interesting here. It says proceeding against person by information, grand jury not required in misdemeanor cases. That all person shall, for an indictable offense, be proceeded against criminally information in second cases arising militias and volunteer forces, national service, or when assembled under arms as a military organization, or leave of the course for malfeasance, or by leave of the course of malfeasance, misdemeanor, extortion, and oppression of office. Others is provided in the Constitution. In that case, a misdemeanor. The legislature may be law dispense with a grand jury and authorize such prosecutions and proceedings before justices of peace of such inferior courts as may be by law established. So that's intriguing there as well. So I got to go right down here. Ex post facto laws, impairment, obligation of contracts, irrevocable or exclusive grants of privileges or immunities. That no ex post facto law nor any law impairing the obligation of contracts or making any irrevocable exclusive grants of privileges and immunities shall be passed by the legislature, and every grant or franchise, privilege, or immunity shall forever remain subject to revocation, alteration, or amendment. We'll just hit 33 here. excuse me. Protection of suffrage. The privilege of suffrage shall be protected by law regulating elections and prohibiting, under adequate penalties, all undue influence of power, bribery, atonement, or other improper conduct. So we've got the protection of suffrage ordeal here. And of course, we just go down. Objective of government. That sole object and only legitimate end of government is to protect the citizens' employment of life, liberty, property, and when the government assumes other functions, it is usurpation and oppression. So you can expect the legislators and the governor of Alabama to use this counter in any opposition. And of course, 36, construction of Declaration of Rights, that this enumeration of certain rights shall not be impaired or denied others retained by the people, and to guard against any encroachments on the rights herein retained. We declare that everything in this Declaration of Rights is accepted out of the general powers of government and shall forever remain inviolate. So, I can work both ways too. Right of privacy, right for life. Going to be a really intriguing case here. I could say in good faith. Only I can recommend to the folks on this issue, on a consensual basis, okay? I'm talking about consensual basis. If folks were sexually responsible, will this be an issue? That's a legitimate question, and I'd be very frank. I get both sides of the paradigm on this subject. Actually, look at me. They gave me that look, like they gave me that stare, like I can't argue with that. And of course, you got to hear about eviction and murder. Always expect that as well. Evict, murder. It's a little disturbing for me, and I say that in good faith. But like I said, I'm not going to try to shove how you folks could think. Well, like I said before, you got to take responsibility for your actions. I don't mean being conscripted or forced upon or being violated. And of course, you got to try to take it to the federal courts. And remember, just to let you folks know, it's the United States of America, not the centralized states. The United States, all the 13 states, started the Constitution, not create the federal government. The federal government is supposed to be limited, enumerated rights, enumerated obligations in the U.S. Constitution. Period. It's interesting about the whole thing about Roe versus Wade. In the judicial aspect, it's mainly a viewpoint, an honorable viewpoint, or an opinion, not an actual law. And I'm not going to go through this in its entirety. But it's really intriguing about some of the laws here, some of the stuff here. And it's like it says here, and the third clause of this law says here, state criminal abortion laws like those involved here, that accept from criminality only a life-saving procedure on the mother's behalf without regard to the stage of her pregnancy and other interests involved, to violate due process clause of the 14th Amendment, which protects state action to the right to privacy, including a woman's qualified right to terminate her pregnancy. Though the state cannot override that right, it has a legitimate interest in protecting both pregnant women's health and the potential of human life, each of which interest grows and reaches a compelling point at various stages of a woman's approach to term. So, based on that, it has like some limitations, of course. And of course, they talk about here about the number 5, It is unnecessary to decide the injunctive relief issue since the Texas authorities will doubtlessly fully recognize the court's rulings, which is 410, Title 410 U.S. Code Section 115. I think maybe that, or maybe that's in the case, as the Texas criminal abortion statutes are unconstitutional. So this could be challenged as well. Like I say, you gotta look at all areas. It's interesting too because they even talk about the first and the fifth. I think the first, fourth, and the ninth on here for sure. But that's one of the reasons why this thing here about this Roe versus Wade is more of a right to privacy, and not have the state tell you what to do. So, yeah, look at it across the board. And hey, I even use this on firearm rights too. Okay, they got the same people that supports a woman's right to choose to have an abortion or not, but they want to try to tell gun owners you have to get licenses to own firearms. That's the right to privacy, an anti-Roe versus Wade. Roe versus Wade platform. Like I said, it's pretty deep here, and like I said, we'll have all the answers, and I boldly admit that. But one thing I like to say here, this is like this about giving a little history here about the ancients and so forth. And as I say, it perhaps not generally appreciated that restrictive criminal abortion laws enacted in the majority of states today are of relatively recent vintage. Those laws generally prescribing abortion or the attempt at any time during pregnancy, except when necessary to preserve the pregnant woman's life, are not of ancient or even of common law origin. Instead, they derive on statutory changes affected for the most part in the latter half of the 19th century. Interesting there as well. So yeah, definitely you guys can read this in its entirety. So I'm going to add this footnotes to the Roe versus Wade case, and you can make your own decision. And to be honest, I gotta say this, that is it. I'd thank everyone for listening. Plus, feel free to download and share throughout your social media networks. If you have any questions, comments, or want to send something that's interesting, I want to check out, whatever you do, please send your correspondence with decorum. Plus, all the footnotes will be on my Spreaker page, and you can check it out yourselves. All right. Once again, thank you for your time. Plus, always remember that demoniac resistance helps with the soul and can liberate humanity. Until next time, take care of yourselves. Keep on spreading the love. And may your guardian spirits be with you.